Thank you. Okay, all right. Okay, calling to order the Town of Edgewood Planning and Zoning Commission meeting for October 16th, 2025. And the time is 6:01 PM. And we'll do roll call. And Commissioner West,
Present.
Commissioner Benino,
Present.
Commissioner Rees,
Present.
and Commissioner Rush.
Present.
And I'm Commissioner Williams, present. Moving on to item number 2, the approval of tonight's agenda.
Madam Chair,
Chair recognizes Commissioner Reeves.
I'd like to make a motion that we approve the agenda from September 18th, 2025. Approve the minutes from September 18th, 2025.
Ah,
Oh,
It's the
sorry.
approval of the agenda.
Oh, I'm so confused
That's
on
okay.
both. I'm so sorry.
You're one
Chair.
ahead. We're on the agenda for this evening.
Right.
Item
What?
2.
Let Mr. Rush do it.
Chair recognizes Commissioner Rush.
Madam Chair, I motion we approve tonight's Planning and Zoning Commission meeting agenda this day, October 16th, 2025.
Second.
Okay. And all in favor, please indicate by saying aye. Aye, and also, are there any nays? Okay, the agenda is approved for this evening. Item number 3 is the approval of the minutes from the September 18th, 2025 commission meeting.
Madam Chair,
Chair recognizes Commissioner Rush.
I motion we approve the August 18th, 2025 Planning and Zoning Commission meeting minutes.
Be September.
I got it wrong. Madam Chair,
Chair recognizes Commissioner Rush.
I motion we approve the September 2025 Planning and Zoning Commission meeting minutes.
Second.
And seconded by Commissioner West. All commissioners indicate if you approve by saying aye. And any nay? Okay, the minutes are approved from the September 18th, 2025. There we go. Thank you. Okay, moving on to item number 4, the acknowledgement of public notice.
Madam Chair?
And Chair was that Commissioner Rush?
Yes.
Okay, Chair recognizes Commissioner Rush.
I'd like to point out that in the publication notice in the newspaper, it references that it was published in the paper on October 6th, which is only 10 days prior to tonight's hearing, instead of the required 15 minutes that's required in advance of subdivision ordinance 2019-04, section 10.a.4. And so you can see that date on the, from the Santa Fe, New Mexican letter that's notarized.
I do see that on here, which is the Santa Fe, New Mexicans. Actually, it was notarized.
Yeah, so they should have published, that should have been published on the, the first?
To provide the 15 days.
Yes. However, what I did find is that, that we actually go beyond what is required in the, to state statute, that in the municipal subdivision final plat hearing, NMSA 1978, Section 3-20-7D, the requirement is to, requires mail notice to the address on the plat, not less than 5 days before the hearing. So the only person that has to be notified is the applicant. Is this the address of, that's on the plat? And the information that's provided is, if I recall, I have to look it up again, it's just the time and date of the meeting. So we actually, our ordinances require more than what's really required by statute. And I'm not aware of anything yet that would indicate that it's problematic that we did it 10 days prior instead of 15, other than violating our own ordinance. And so with all that information, I leave it to the other commissioners as to input what their thoughts are and how we should proceed.
I do agree with Commissioner Rush's analysis of the dates, and I do agree with his bringing forth the NMSA 1978 that does require, it's the minimum requirement, and then our ordinance does go above and beyond that. Yeah, so we would, any discussion on that particular item, commissioners?
I think the state statute is fitting to go ahead and proceed with the agenda tonight.
Madam Chair,
Chair recognizes Commissioner Benino.
I believe as far as the fact that we have many other avenues to notify individuals via mail and other notices, posted notices, I feel there is adequate notice for this.
Madam Chair,
Chair recognizes Commissioner Reeves.
I would agree with the other commissioners and what Ms. Bonino said about other notices, and that it is probably prior proper notice.
Madam Chair,
Commissioner West.
if we look at 7D, it says that the hearing be held is waived by the person seeking approval of the plat. So I think we need the gentleman's approval to go ahead and proceed, if I'm reading that correctly.
Could you restate that so I can hear you again?
Last sentence in 30-20-7D says, "No plat shall be acted upon without public hearing unless the requirement that a public hearing be held is waived by the person seeking approval of the plat."
So I think at this point, what we need to do is, we do need to ask the applicant if he is, if he's okay with us proceeding with that in mind. And then we will entertain a motion so that we can have it on record that we would proceed based on the discussion that we had. So do we have Mr. John Bradley? Okay, if you'll just come up, we're not going to put you under, well, let's see. This is still with regard to you, so I think we'll go ahead and do the oath, please, first, before we ask him any questions.
Do you swear or affirm, under penalty of perjury, that the testimony you provide for this hearing matter is true and complete to the best of your knowledge?
Okay, Mr. Bradley, based on the notice in the newspaper that was done on the 6th of October, which was less than the Town of Edgewood's ordinance of 15 days, are you, as the applicant, okay with us proceeding?
Yes.
Okay.
I have gathered what was going on with the newspaper was, should have been, I guess that notice should have been published a little sooner. But yeah, I'm totally moving forward.
Okay, okay, so thank you. So we will proceed with entertaining a motion that we go ahead and proceed with this based on the discussion that we just had on the
Madam Chair,
one item. Chair recognizes Commissioner West.
I'd like to make a recommendation for the approval of public notice in the Santa Fe, New Mexican, and also the postings of the photographs that are provided for the property.
I second the motion.
Okay. All right, let the record show Commissioner West made the motion and Commissioner Rush second. And commissioners, all in favor, please indicate by saying aye.
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 And any commissioners indicate nay if you don't agree. Okay, that motion is passed.
Madam Chair?
Chair recognizes Commissioner Rush.
So in the past, our process has been for roll call to acknowledge the notices, the public notice letters, the posting, and the Santa Fe, New Mexican. I'm assuming we'll proceed with that still?
Yes. Okay, item number 5, we do not have a notice of decision or finding of facts or conclusions of law to attend to.
Madam Chair?
Commissioner Rush?
On agenda item 4, do we want to do a roll call that each commissioner acknowledges the public notice letters, online posting with Santa Fe, New Mexican in the signage? Has been our process in the past.
So I think there's been a motion
In a second.
and a second on that, so I think he's asking for a roll call vote.
Mhm.
Okay, so let's take an oral roll call vote.
Okay.
Let me maybe clarify so in the past, what we've done a roll call for each commissioner to acknowledge that the public notice letters have gone out, that there's a picture provided that shows that the signage has been posted, and that there is a online posting in the Santa Fe, New Mexican. What we've done so far is to acknowledge that there was by ordinance, we didn't get the Santa Fe, New Mexican online posting done in time. What we haven't done so far, like we have in the past, is to acknowledge the letters, the postings, and the signage.
Definitely agreed.
And
Thank
so
you for
I-
bringing that to our
Okay,
attention.
so-
And Madam Chair, do you normally do that before you consider the application or after you consider the application?
For the acknowledgement of public notice, prior.
Okay, all right.
Madam Chair, I just wanted to ask, prior to, I believe, Commissioner Rush coming on board, I thought sometimes we had just done it with a motion and all in favor, aye. Is that improper?
No.
I'm just curious.
But I
Okay.
think
No,
Commissioner,
People got in the habit of doing roll call votes during COVID because you didn't always know who was in the room.
Okay,
And then certain procedures require a roll call vote, usually
Mhm.
closed sessions. Acknowledging notice or approving doesn't always. Some jurisdictions do a roll call vote after everything, so
okay,
it's belt and suspenders, it doesn't hurt,
okay,
okay?
thank you.
and I think Commissioner Rush had a kind of a valid point about, we did a motion and second and with regard to the ordinance and the NMSA and how that played a part in the posting in the newspaper. But we did not actually do the acknowledgement of the remainder of the postings for
The letters
the
and
proceeding.
posting. Yeah.
Okay, So we'll go ahead and do a roll call vote for the acknowledgement of public notice for the matter before us this evening. And that is of John Bradley. So we'll start with Commissioner West.
I acknowledge the public notice.
Commissioner Benino.
I acknowledge public notice.
Commissioner Reeves.
I acknowledge the public notice for agenda item number, oh, I'm so sorry, 7?
Seven. And Commissioner Rush.
I acknowledge the public notice letters, the online posting with Santa Fe, New Mexican, and the signage for agenda item 7 of tonight's agenda.
And I, as Commissioner Williams, also acknowledge the public notice for agenda items number 7, and that is in the newspaper and the letters. Okay, we're going to move on to item number 6, which is general public comment. This is for information only. Participants, wishing to speak on topics that do not appear on the agenda will be given 3 minutes. No action can occur on these items, and this is not the time to ask questions of the commission. If you have questions, please feel free to contact the staff during business hours. So we will call for public comment. Mr. Mark Mull.
I thought I made a comment on the sheet, no comment.
Okay.
I have no comment.
Thank you.
I thought it was an attendance.
Okay. And quasi judicial procedure. Let's see, Rebecca is the acting planning and zoning manager. If you would read that for us, I would appreciate it.
So it's quasi-judicial matters, certification that public notice of this meeting has been posted as required. This case is being heard in the provisions required by the New Mexico Court of Appeals intended to protect the rights of all parties and their witnesses, and the swearing in of all parties giving testimony. The applicant, the affected parties, and zoning officials and commissioners will have the right to cross-examine persons giving testimony. And the commissioners will provide confirmation of no conflict of interest or ex parte communication.
Thank you. So we will go with each commissioner, and we'll ask that they provide confirmation of no conflict of interest or ex parte communication on item number 7 of tonight's meeting. And Commissioner West.
For item number 7, I have no conflict of interest or ex parte communication.
Commissioner Benino.
On item number 7, I have no ex parte communication or conflict of interest.
Commissioner Reeves.
On item number 7, I have no conflict of interest or ex parte communication.
And Commissioner Rush.
I, Commissioner Rush, have no conflict of interest or ex parte communication regarding the quasi-judicial matters before this commission tonight for agenda item 7.
And I, as Commissioner Williams, have no conflict of interest or ex parte communication on item number 7 on tonight's agenda. Okay, and as acting planning and zoning manager, Rebecca, would you let us know what this application is for?
So item number 7 is for final plat approval. The application is for approval of plat for subdivision. The applicant is John Bradley as owner and agent. The request is to divide 1 lot into 4. All resultant properties will be subject to conditions identified in ordinance 2019-04, section 10, and any further conditions determined by the Planning and Zoning Commission. Subject address is at 1 Taxiway Sandia. The legal description is 10 T10 North, R7E, section 13, tract B3. Acreage is 23.92. It's also identified as parcel number 944-75392. The property is fully located in Edgewood, Santa Fe County, New Mexico, 87015, and the property is currently zoned R1.
Thank you. And at this time, we will, we've already, I swore, Mr. Bradley's been sworn in. Are there any witnesses that are going to be called this evening that we need to also swear in? And no one is stepping forward, so we'll move on. So testimony from applicant. So Mr. Bradley, if you'll please go ahead and present your application. Just give us some general information on your proposed.
Yeah, I think you guys are pretty familiar with the proposal. We put in the application about a month ago. We've been working on this project for a little while now. It's subject property is, like she said, number 1 taxiway Sandia. We're going to cut it into 4 properties, 3 5-acre lots. 3 lots that are 5 acres and 1 lot that is 8.92 acres. And we will be providing a utility backbone and road access to, well, the road access is already there, but yeah. So basically just minor subdivision.
And commissioners, do you have questions for the applicant?
Madam Chair,
Should I recognize this Commissioner Rush?
I have a few questions that I need to ask. And before we do, I need to make sure that I follow proper protocol when referring to our attorney, because I always keep referring in my mind as Nan, but it's Nan Winters, correct?
Correct.
Okay, thank you, ma'am. So Mrs. Winters is fine, or Miss Winters?
Winter, no S.
Okay, Miss Winter, okay. Okay. Mr. Bradley, one thing I need to do in looking at your application is I need to understand the appropriate documentation showing legal or equitable ownership interest. And if you need to, I can quote the subdivision ordinance. My understanding in the deed, it excludes community ownership since it includes the following language that says, as his sole and separate property. So if you look at the deed that you provided, it hereby grants to John Bradley, a married man, as his sole and separate property. And so this is where I could use help from Ms. Winter to make sure that I interpreted this correctly, is what that says is that it does not provide equitable ownership interest for his wife that is referred to because it says he's a married man. So because it says he's a married man, that says that he has a wife, but because it says as his sole and separate property, what that means is that that this deed excludes her from having equitable ownership. So what we need to what I need to understand is if you're married, is the person you're married to, are they supposed to have equitable ownership? Because if they are, then we need the documentation to prove that, because this deed excludes that.
Madam Chair, Commissioner, so this means he just owns this property all by himself?
That's what that deed says.
That's what the deed says?
But the deed also says that he has a wife,
And I think,
Yeah, okay, that's fine.
right?
Yeah.
That's normal.
So community property applies, but it depends upon when he acquired the property. So we've got some questions. So I think what I understand you're saying is, my assumption is correct, that this deed excludes his wife, and we know he has a wife because it says he's married. And I'm assuming he's still married. And so that would be my first question, and I'm assuming I can ask that question. If you're Mr. Bradley, are you married, or and are you married to the same person that when you received this deed?
So, I'm here in representation of the property owner, which is my uncle, John Bradley. I have, a power of attorney for the subdivision and like the town council hearings and all that stuff, that has to do with the subdivision. So, as far as him still being married, I want to say that legally he is married.
Okay, Madam Chair,
I think I
And-
understand the question and your concern, so.
well, not, but I think we've got a bigger problem now.
Okay.
Okay, so Madam Chair, so apparently there's two John Bradleys. There's a John Bradley on the deed, which is your uncle, and there's you as John Bradley. So you're an agent, but you're not an owner.
No, I'm not the owner of the property.
Okay, so I think we need, so we need,
Applied as an agent, right?
We need
okay,
the
now my
agent.
mind's, I've kind of gotten twisted around in my head as to what we need for owners, because he's the applicant and not the owner. Because his application says he's the owner.
So we need a letter of authorization if an agent is applying on behalf of the owner.
Do we have that?
So that's what we need, is a letter of authorization.
Thank you.
Madam Chair,
Chair recognizes Commissioner Reeves.
I think Mr. Rush, or, pardon me, Commissioner Rush brings up a good point, which Ms. Winter will have to chime in on, because New Mexico is a 50-50 state. And so if there is a wife listed on the deed, I would think that that could get very muddy,
So Madam Chair, so
or referenced, sorry, not listed.
Madam Chair?
Chair recognizes Commissioner Rush.
So I think we have two issues at this stage. One, we need the letter authorizing representation, and two, we have to resolve the ownership question with the wife.
Yes.
And Madam Chair, I think I can shed some light on the ownership representation, right? So when you're married, this is like fundamental black letter law. When you're married, you create an estate. Houses, cars, properties. And if you get divorced, the community is split 50-50 in New Mexico. But you have the opportunity to take things out of that estate by agreement, or by deed, and that is when you take title to something as a sole and separate property. And you can do a sole and separate agreement as well. And then with that agreement or that execution, you are pulling that asset out of the marital estate. So it is fairly common that certain assets are pulled out of or never in the marital estate. Now, could they fight about it later on? Yes, they could fight about it later on.
Madam Chair.
Chair recognizes Commissioner Reeves.
Ms. Winter, when that scenario that you just described happens, is there documentation in that? I mean, if they're still legally married, but maybe separated, is there any kind of paperwork in that scenario that we should have proof of?
I mean, as long as it says as his sole and separate estate,
Right.
you can rely on that in a deed. If you see a sole and separate property agreement, you can rely on that. But a separation agreement doesn't usually
Right.
address sole and separate property, not usually. Not usually.
So my understanding is that we don't have a wife issue, as I was saying, that we have two issues at this stage that needs to be represented.
I don't think there's a wife issue.
Okay,
So there's just a represent, I'm sorry.
yeah, so there's, I'm sorry, I interrupted,
No,
Madam
it's
Chair.
okay, no, it's okay.
So
I'm
we
just
need to,
following.
we need to resolve the representation letter issue.
I would agree.
Madam Chair, as in another thought, Ms. Winters, is it a problem that, so we've gone through the preliminary process without the same documentation? Is that an issue that has to be resolved?
If there was no authorization letter, did you fill these out or did your uncle fill these out?
I did,
You filled them out?
yes.
But you didn't indicate that you were an agent?
Correct, because organization, correct?
Do you have a copy of the power of attorney?
Yes.
That might resolve it.
Madam Chair,
Chair recognizes Commissioner Reeves.
I remember Mr. Bradley coming before us previously. I was on the commission. Mr. Bradley, can I ask you, did you provide that power of attorney for the other matters that we oversaw concerning this property?
No, I don't believe anybody's ever asked me for it before. I've always had it, or I've had it since, sorry, it's dated, I have another copy.
That's okay. But
But,
Ms.,
basically, the first town council meeting I attended, I was under the understanding that it was, anybody that was representing the owner of the property was, you guys called that person forward, which was me at the time, so I've been handling the ins and outs of the subdivision, so.
Ms. Winter, does Mr. or does the town of Edgewood, I guess, need to attach that power of attorney to other matters that we've overseen?
Absolutely.
Okay, that's really where my questioning was going. Because we have, I'm sorry, I won't have exact terminology because I don't have that meeting in front of me. But I know that we have done approvals for Mr. Bradley in the past concerning this exact piece of property. I think you've been here twice already, haven't you?
I believe this is my third meeting.
That, yeah, you had a continuance, didn't you? Because I think, Mrs. Garcia, that we need to go back in your filing system and add that power of attorney to anything that this commission has done in previous agendas for Mr. Bradley. Okay.
For this application. Oh, here it is, never mind. Okay, Madam Chair, let me read this limited power of attorney into the record, and I think we make it a part of the record and include it in the packet, in the file for this application. It's I, John E. Bradley, hereby appoint John P. Bradley as my attorney in fact to sign any documents in my absence for any documents, orders, or any matters pursuing subdivision of this lot or obtaining quotes for all matters regarding Tract B3 as shown on plat entitled Land Division of Lands of Richard Dennison, Tract B within the north half, Section 13, Township 10 North, Range 7 East, NMPM, also known as Number 1 Taxiway, Sandia, Edgewood, New Mexico. This limited power attorney is only for this singular purpose, and he puts an exclamation point after that. So I'm comparing the legal descriptions now to confirm that we're in the right place. And it does look like they match. So, and again, we'll make it part of the record of this application.
Thank you so much.
Madam Chair, if I may ask Ms. Winter another, so I just want to verify, because this is the way I am. So we can proceed even though we had an issue in the past, but we've just fixed that. Is that my understanding?
Yes, I mean, we've supplemented the record. I mean, this is a hearing where you're taking evidence. The evidence includes the packet, the application. You raised an issue with respect to authority to pursue this, and we are now supplementing the record and correcting that with this power of attorney, limited power of attorney.
Okay, and then, so this power of attorney references regarding the plat that's entitled Land Division of Lands of Richard Dennison, but we're looking at a new plat tonight. But since, and this may be splitting hairs, so the original plat would be Land Division of Lands of Richard Dennison. And so, I guess I'm getting a little bit confused. So now we're Land Division prepared for John Bradley is what we're preparing tonight.
Correct.
Which is based on this property that this,
Correct.
so,
So, Madam Chair, Commissioner, there is a plat existing right now that's entitled Lands of Richard Dennison.
correct.
And the goal of the process tonight is to replat that subdivision. And so there are drawings in the package that show the new subdivided plat. So it's, we are tracking. I mean, it is following, to me.
Okay, Madam Chair?
Chair recognizes Commissioner Rush.
Okay, I think for this issue, I think we can proceed, that we've taken care of this one point.
Thank you for bringing that to our attention, Commissioner. Appreciate it.
You're welcome. So Madam Chair, I still have some further questions.
Proceed, Commissioner
Okay.
Rush.
So, thank you, Mr. Bradley. You have a will serve, what's called a will serve letter from EPCOR, and in that letter, it has the condition that you obtain the necessary water rights that can be transferred to EPCOR. So my question is have you obtained those water rights that are referenced in the will serve letter?
As far as EPCOR goes, I reached out to them, and they said that they couldn't move forward with anything until this final plat hearing was all taken care of.
Okay, but so it says here that water service to the development by EPCOR will be conditioned upon the developer, and I'm assuming you're the developer, acquiring adequate water rights to serve the development. So the way I interpret this, and I was hoping that Ms. Winder could help me make sure I'm reading this letter correctly. But in order for you to have water, my understanding is that you have to obtain the adequate water rights then conveyed to EPCOR. Is that how you read that sentence, that last sentence in that letter, Ms. Winter? So the way this is written, I don't know that, what has to occur for water to be provided to the subdivision.
Yeah, I agree. This is a different letter from EPCOR than we've seen previously.
Yeah, Madam Chair, Commissioner, EPCOR is telling him that they will serve, he will be subject to EPCOR's tariffs, rates, and services, rules and regulations, but that it is conditioned upon him acquiring adequate water rights to serve the development. That is a correct statement.
So my interpretation is that they will serve it when he gets the water rights, but I'm concerned about approving the plat because I don't know if he's gonna have water, because I don't know if he can get the water rights. And so that was the reason my question was, has he obtained the water rights? And it becomes a chicken and egg thing, which has to occur first.
Well, I think you should definitely ask him what his intent is with respect to water rights. I mean, does he?
So Mr. Bradley, I think that was kind of the question that I'd asked, and maybe I got muddled with it, but have you been able to obtain the water rights as conditioned in the will serve letter?
I thought the water rights came with the water provider,
Yeah.
whatever we get approved with the subdivision, and the water provider is, so I didn't know that was separate. Yeah, I haven't moved forward on any of that, no.
So, yeah, so then, okay, so the answer is we haven't obtained those yet. Do those need to be attained before we can proceed?
Madam Chair, Commissioner, you can certainly approve with the
With the
condition. With
Okay,
the condition
okay,
that he satisfies the EPCOR requirement.
okay.
And then he doesn't have to come back and ask
Right.
again. Right.
Right, okay.
Madam Chair,
Chair recognizes Commissioner Reeves.
as you and I had looked at each other a second ago and said this letter is different, I hesitate on approving with condition, because what if obtaining those water rights are not obtainable for this applicant, meaning I actually don't have the knowledge of what it takes to obtain the water rights. And we haven't seen this from EPCOR before. And I have concern that once he goes down that path of discovery for his development, he might, I don't know how I'm trying to put this, but I question why EPCOR put this in, and we haven't seen it before, and so I think that I personally would like some answer as to why they did that and what their thought process was for putting this in this particular letter where we haven't seen it in others.
I agree that there is some question. Unfortunately, EPCOR is not here to answer
I
that.
know, I realize that.
So, so question to the Planning and Zoning Department would be, in the process, if the water rights are not obtained, then the next process is not, it cannot move forward. Whatever the
That's what I'm-
development review,
That's what
believe,
I'm
would be the next
saying.
one. Because this is the final. So upon,
Ms. Winter, could you, oh, I'm so, I jumped over you. Madam Chair,
Chair recognizes Commissioner Reeves.
would you please give me a very brief education on how one would obtain water rights? And I'm sorry that I don't have that
It-
knowledge, as a property owner myself, I just have not ever had that experience in life. And that is why, as just a single person stepping out of this commissioner role, I am asking the question.
Right.
Okay.
So let me back up just a moment, Madam Chair. This is just a subdivision approval, right? This is not a development,
Right.
right? So he's gonna have to come in and he can't develop this until he knows he has all your checklists covered for a development agreement. And water's gonna be another issue, it's gonna be an issue again. So to obtain water rights, generally you talk to a water broker. I mean, there's water brokers in the state. Water law attorneys
Okay.
usually have some knowledge of who might have water rights. They are hard to come by depending on the basin. I don't know much about, I know that you all have a lot of litigation in this basin and have had a lot of litigation. He could get it from a neighbor, a rancher, a water broker. I'm gonna guess a development of this size is not going to need a lot, right? A few acre feet. So that could come from anybody who might have something here in the vicinity. And maybe a water broker has that information. I do know that one of the New Mexico water brokers does operate either here or in Moriarty, somewhere in here. So, but yeah, it's something this size is not gonna be nearly as difficult as citing, a 150 home subdivision. So chances are, he might find something.
Madam Chair?
Chair recognizes Commissioner Rush.
I think there's also the possibility that EPCOR may have just wrote a really bad letter for this subdivision, and that maybe EPCOR just needs to write a better letter, and maybe this was their attempt at some, and I'm gonna pick on Ms. Winter, this, what I would call an attempt at lawyer English, that the way we read it is one thing, but what they intended was something else. So there's a chance that EPCOR may have intended to really provide water for this, but this is how they wrote the letter. I think we have seen this letter in this writing before, and I think in the past, what we were told by a previous planning and zoning manager is that yes, this was the letter that they sent, but yes, water was going to be provided. So, but this was also an opportunity to ask Ms. Winter what that, if I was interpreting the letter correctly. And so I think there's more questions that I have that need to be addressed. I think we need to proceed and then look at the total picture of the things that need to be done, and then discuss that some more, and then decide how to proceed.
Madam Chair. Chair recognizes Commissioner Benino.
Mr. Bradley, can you tell me how close the Epcor water currently is to your land?
I would have to, just an estimate, and say about 600 feet.
600 feet?
Yeah,
Okay,
yeah, less than a mile. I mean, way, less than a half mile, I would say,
right,
for sure.
right.
So, I mean, half mile is what, like 2,000 feet, so yeah. I would say definitely less than a half or a quarter mile. I'd have to speculate. I don't know.
Sure, sure.
Yeah.
So I think to me, it sounds like you need some clarification from EPCOR as to whether or not, if you pay the amount of money they require to hook up, do they have adequate supply in there, or is their letter saying, we don't actually have any water in that area to supply you with, so you'll have to go get it yourself?
I mean, once I got the will serve letter, I thought that they were the water broker, as you put it, and that they would provide the water as soon as we would get the final plat hearing and get an engineer out there to take a look at it or hire them as an engineer. They have that as an option. So, I mean, like I said, I didn't notice that last sentence. I'm not savvy with a lot of this stuff, so.
It is kind of a confusing letter, because in
It
one
is.
area, it says EPCOR will provide water service to the property in accordance with their tariffs, PRC, and if applicable, terms and conditions of the main extension agreement. And then it says it is the applicant's responsibility to design, construct at its sole cost the necessary water facilities to serve the property, which is what you're talking about, is
Right.
the actual connection and,
Yes.
yes.
I think
So-
it could just be a as Commissioner Rush suggested, that perhaps they just wrote the letter poorly. But I think you need clarification on that to know how you need to proceed for this.
I mean, this was last meeting. Okay.
So, Madam Chair,
Chair recognizes Commissioner Rush.
if there's no further discussion at this time on this particular point, I'd like to proceed with some additional questions.
Any other commissioners have questions about the EPCOR letter before we proceed to? Okay, all right. Commissioner Rush.
Mr. Bradley, so there's, most of my remaining questions deal with the actual plat. And so my next question deals with two things, the easement that's on the south side, and also the fact that, and first of all, what I'm going to say is, I'm going to assume, just for the way ordinances have been referencing overlay zones, that a runway overlay zone is the same thing as an airport safety overlay zone. So in our zoning map, we have a runway overlay zone, but in our zoning ordinance, we talk about an airport safety overlay zone. So I'm assuming those are going to be the two things, or the same thing. Does that make sense?
Yeah, it's basically, this is something that my uncle incorporated into this area, I mean, as kind of,
Well,
like an HOA.
Well, if we look at the zoning map, we can see at the end of the runway, there's actually a overlay zone, and it's a moot point whether it's whether it's a runway overlay zone or a airport safety zone. The city has determined, the town has determined that there is an overlay zone there. And so where I'm trying to go to is that the zoning ordinance requires that you provide a map or a drawing of the airport imaginary surface. And I can go into that, and there's a lot of detail in the zoning ordinance as to what that is. And basically, all it is just kind of a parallelogram that just would show on the map, on the plat. And so it's required that you provide that map. And so, but my requirement, I think it's best that we put that on the plat. And so, so that way when somebody looks at the plat, they'll know that you can't extend into that airspace. There's a couple of different definitions that go into that, and some dimensions on width and how far out it goes and at what slope that occurs. If I remember, I think it's 2,500, no, it's 200 feet. It's a rise and run. For every foot up, I think you go out 200 feet or something like that. But anyway, there needs to be a drawing of the airport imaginary surface that it's defined by the primary and approach surfaces that need to be included on the plat.
Could you repeat what that drawing, what that's called, please?
Okay, it's called a airport imaginary surfaces that's defined by the primary and approach surfaces. The zoning ordinance actually defines what the primary surface is and what an approach surface is and what an airport imaginary surface is. So if you look at the zoning ordinance, it defines those parameters. But if you look at the actual ordinance, in the zoning ordinance, the number of the ordinance is 2024-017, and it's section 25.3.D.1. And that defines the requirement of having this drawing and this map. And I think it's best to put that on the plat. And I tried, in our last meeting, I tried to have that put on, but it didn't get there. And what that does is it allows you to see where you need, because if you build something too tall into that space, then that's a violation. And so by having it on the plat, you'll know not to put anything too tall there. And then who draws up your plat just needs to be, just look at those requirements and just draw it accordingly.
Yeah, my surveyor thought this would be adequate, so I guess I'm gonna have to find another surveyor.
Okay. So
You said that's section 25.3
D,
as in Bravo,
D as in dog.
Delta?
Delta, David, yes.
It's labeled as procedures.
Thank you.
So it's, just to help you a little bit also, it's airport safety. So that section 3 is titled airport safety. And D, under that section, is procedures. And that's where you'll find that information.
Page 60. Page 60.
Madam Chair.
Chair recognizes Commissioner Rush.
And so I'll proceed if everybody's ready.
Do we have any other questions on the airport safety piece of what Commissioner Rush identified?
Okay,
Commissioner Rush, proceed.
Mr. Bradley, so I do notice that you have the easement on here, but referring back to the zoning ordinance, it requires that easement must be dedicated to the airport sponsor. And so my question would be, has the aviation easement been dedicated to the airport sponsor?
I would say no. I believe in my mind, the sponsor is my uncle, so that would be the owner of this property, but because he created this
Understand.
this easement to begin with on his other previous properties. So
And-
it's not directly in line with the runway either. I mean, it's offset a little bit, just, I don't know if
Okay.
that matters.
And I understand, and I apologize, this is a little bit painful, but I think this is what the ordinances require. So I'm just trying to follow and do the right thing, keep us all out of trouble. So what, part of that additional requirement with the airport sponsor is that the easement has to be acceptable to the airport sponsor. And so-
You're getting, I'm sorry, go ahead.
Okay, and that's fine, you can ask me questions, but so you have, by the ordinance, you have to dedicate that to the airport sponsor. But the easement has to be acceptable to the airport sponsor, and so I don't know if the easement you have drawn on here is correct to, is acceptable to the airport sponsor, and so I don't have that information, so we don't know, since we don't have that, and you don't have that to provide, I don't know if this easement is correct.
Okay.
And-
Madam Chair, Commissioner, I think it's identified as having been filed of record on book 1897, pages 747 to 749. So I think we just need a copy of that.
That may be it, yes.
Right, so we need a copy of that to confirm that it's clearly dedicated. The question is, who is it dedicated to, I think.
And I didn't even know enough to know that that's what that meant down there.
Yeah, it's recorded.
Okay.
Somebody's recorded it. So the surveyor did pick it up.
May I ask you what book, that information, where to find that?
Santa Fe County Clerk.
And what book was that? You said 1897?
Yeah.
It's on the plat? Okay,
Mhm.
I'm sorry.
So it's obviously recorded. That's a recording.
Thank you.
Yeah, he might be able, I don't
So
know
your
if he can
surveyor will
get
have
it.
He found it and put it on here.
I don't know if that's something you can online or.
Yeah, I think the other requirement is that the easement is signed and recorded in the deeds records of the county. So, yeah, that's what that's referring to,
It's
isn't it?
clearly recorded.
Yeah, that
Yeah.
might be something that he could obtain even online, possibly.
Well, if his surveyor picked it up, his surveyor has it,
Okay,
okay? So he doesn't, yeah, but you can go online and look for it too.
it's possible, yeah,
Right. They'll charge you $1 or $2.
yeah.
Yeah, when we went over this plat, that was, the whole thing was about the runway easement, and, I asked him to write it up the way that he best saw fit, so I guess that's what he referenced that
But
perhaps
he
is
should
why
have a copy of it.
So, Madam Chair, I'd like to ask Mr. Bradley if that road and cul-de-sac that's been added to service these lots, is that a private road or is that a public road?
So that'd be a private road.
Okay, and so, I guess I'd have to ask, okay, no, so that must be documented on the plat that it's a private road. And then when I'd ask my fellow commissioners if anybody knows, when, does that get named and who names it? And when does that get named?
Yeah, we named it, we're talking of rural addressing right now. They're
Okay.
working on this also
Oh, okay.
before we can name the road. We're calling it Pilot Place.
Okay, okay. Madam Chair, have one more bit of information. So within the subdivision ordinance, there's a section that lists the information that needs to be on the plat. And so I've got a list of information that I'd like to go through that I think is missing on the plat per the ordinance. And so I'm going to go through those if you like, and I can give you and it's all in section, it's in subdivision ordinance 2019-04, and it's in section 10, dot B, and there's sections dot 3 and dot 4 is where all this is listed.
Thank you. Yes, go ahead.
And so my first question is, what's the name, the legal description of the subdivision? I wasn't too sure what the name was, and I know this says land division prepared for John Bradley. I wasn't too sure if that was the name or not for the subdivision in the legal description.
Madam Chair, the Commissioner, the legal description is at the very top of the page.
Okay, so that takes care of that. That was just me not knowing any better. Next question is, the address of the applicant needs to be included? Because even the state statute says, we send the notice to the address that's on the plat, and I didn't see it if it's on there, the address of the applicant.
Oh, you mean on the plat? So
Yes.
All the stuff that, yeah, so I asked my surveyor, he said all that stuff will be filled out after the plat hearing is approved, so.
Well, I understand, yeah, there's blanks for signatures, but there's no address. And so I guess, whose address, the agent or the applicant? The owner the owner should be on there. So that would be, your uncle, John
John E. Bradley.
E. Bradley. So his address needs to be added on there? And then we've already discussed that we need to include that it's a private road. Some of these next issues are I want to include them because they're specified in the ordinance. So the requirement is existing and proposed conditions of the site. And so it repeats the site designation or subdivision name. And so we've affirmed that that's the top of the plat. It needs to indicate what utilities are on or adjacent to the plat. And I saw where there's a utility easement, but it didn't tell me what utilities are actually there. My interpretation is that it needs to specify, that you've got water to this point, or you've got sewage, or you've got power lines, or you've got phone lines. Where are those located? That's how I interpret that.
And I
Madam Chair,
wonder,
Commissioner, generally, that's a public utility easement, and you don't, anybody can put anything in there, and they're not usually, until somebody puts something in there, you don't know where it is, but there's a dedicated PUE on here already. So I'm gonna guess that there are no utilities in the PUE at this time, it's just it's reserved for public utilities.
Okay, so
Is
and there's no power lines nearby.
I do not see a power line easement in this plat. I see the PUE, I see the public utility easement. And my guess is power would probably come in through there.
and they have, is that where you're seeing also book 294, page 26? I might not be
Correct.
looking at, okay.
Yes.
Yeah.
So if there was something, I'm assuming that it would be recorded in
If
that
there-
book also.
If there's something dedicated to P&M, or I guess this is Central New Mexico,
Yeah.
it would be in there.
Okay,
And there's a good possibility they're there already anyway.
okay.
I mean,
There is a power line, east of Candace Lane.
yeah, unfortunately, in these situations, people were granting easements on a handshake, so, they could very well be there already and not.
So Ms. Winter, so the ordinance actually specifies that it will, document what existing utilities are on or adjacent. And so, if I understand correctly, you're saying that that's not really needed. So if that's the case, then that needs to be deleted from the subdivision ordinance. Is that my interpretation?
I think it needs to say that if there is an easement with Central New Mexico or an easement with gas company, that should be on here.
Okay.
Thank you,
So
ma'am.
He has shown two public utility easements, so there's two PUEs on here. They've both been filed. My guess is they might indicate who the grantor was and who the grantee is.
And so that should be good enough, as long as that's in there and we
Yes.
could clarify.
Yes.
Thank you for educating us, and we'll just need to update the ordinance accordingly.
And you will need for him to probably give you those copies of the PUEs. Along with the airport easement. Right, and again, the surveyor's gonna have this because he noted them. And I've only had like 10 minutes to look at this. I apologize for not looking at it in this kind of detail, but, I'm only seeing two public utility easements right now.
Mm-hmm.
Yeah, I only see two.
Mm-hmm.
So, and again, there might even be something out there that's not on here because it's unrecorded.
No, there's another one right there. There's one here.
Yeah.
One. Here.
Oh, is there another one? Or is that the same one? Book 294, page 26?
They all
Oh,
say
the-
book 294, page 27.
Okay. Has to be this, that would be this,
So I'm going to guess, based on what Mr.
Oh,
Bradley just said, that if Central New Mexico is on Candace Lane, I'm going to guess that Candace Lane has that public utility easement running east and west, too. Just guessing. But they might not be there, but they have the right to be there.
As long as they don't interfere with the airport airspace.
Correct, so,
Which is a good reason to have that
right.
overlay zone on there.
Yeah, and yes, they'll have to work with each other. They both, it appears they both have, see, is that a, they both have easements covering the same space. So, I'm gonna guess they know about each other, that's for sure. These are both filed.
The airport safety overlay easement is an elevated plane,
Right,
sloping plane.
right.
Madam Chair, if I may proceed.
proceed. Commissioner,
So the next bullet, the next bullet that's required is existing storm drainage. Needs to be documented. Significant structures or trees. I did look on Google Earth, and it looks like there's some structure, maybe over in track 4. It looks like maybe a transportainer. I don't know how significant it is, but whether or not that's a structure or not.
No, there's no structures on the subject
Okay,
property.
there's no transportainer or anything over there. It just, that's all I could see on Google Earth.
Transportator,
A transportainer,
transportainer,
yes.
I'm not familiar with,
Okay.
there's no buildings, there's no
Okay.
dwellings,
Yeah, you,
barns or anything like that.
yeah, you can't specify something that's on there if it's not there, so, but I didn't see anything, so fair enough. Talks about, and so the other problem that's missing on these is that it's required to have, direction of gradients and ground slope. Preliminary plat requires contour lines, so those are missing, so it's conditions of adjacent land. And again, these are just requirements from the ordinance.
I have a question for Mr. Bradley, if you don't mind.
Sure.
Did your surveyor give you, is this all that your surveyor provided to you when they did the survey of the property?
I mean,
Was-
this was the most revised,
Yeah, was just
Flat.
this piece right here.
yes.
Yeah, they didn't give you anything with, that has some of these other items on the,
They didn't do a topographical survey, no.
okay,
No, that's.
It's a separate cost.
yeah, okay, all right.
Falls under construction.
The next requirement is that you have zoning on and adjacent to the site. Those zonings are missing, I believe, the names of the adjacent site. The adjacent owners are required,
And I think
but
we
it's missing the one to
yeah.
the east.
There's a road there, right? But there's a road there, right? So
Well, that's,
You
is that the,
require-
next
Yeah,
to the tax?
so
on the
do-
other side of Candace
So
Lane.
does the road,
Ah.
does the road negate that requirement in the ordinance?
Well, it is considered the eastern boundary.
I'm sorry, I didn't hear you.
It is considered the eastern boundary, the road is. In other words, that's a public road right there.
So we wouldn't need the property information on the other side of that road? Only the property that abuts up?
Correct,
Thank you.
usually.
Does that help? answer the
Yes, yeah,
question?
I mean, that answers that question. I just
Okay.
didn't know any better. Ms. Winter, is there a reason why the ordinance requires or requests adjacent owners be included in the plat? Because if they moved, then the plat's wrong, and the plat never gets updated. So what's the value added of that information?
Madam Chair, Commissioner, I mean, a few things. It facilitates notice. It helps staff understand who needs to be noticed in the event of something. And it facilitates notice to the other owners as well. Not only does staff know, but the other owners are informed of it as well. So it's a pretty standard requirement
Is it, okay.
in most plats.
And I think zoning is important, because when you think about the zoning, then it helps you think about the overlay zones. And so I think that overlay zone is very important to have for that, for the airport. And so I think it's good to have that zoning information on there with the overlay zones. So the next requirement that I see that was missing was county treasurer certificate for the previous 10 years. The taxes have been paid, unless I missed that on there. And that's required by section 10.b as in Baker, .4.e.2.
On what page, Commissioner?
I have to look it up. So 10.b.4.e, that's on page 19,
Okay.
or underneath certificates.
Certificates or
Certifications, I'm sorry.
Yeah, the appropriate county treasurer that the previous 10 years' property taxes due and payable have been paid. Mr. Bradley, I know this seems very tedious, but we're actually just going right down the list of final subdivision in the ordinance. So that's, yeah, that's what we're going down, just each of the line items.
I understand. I just feel like he probably should have got a lawyer and not me, so I'm a little bit overwhelmed here.
I can understand, I can understand.
I was supposed to build the road for him.
Well, this is online,
Okay.
the ordinance, so it would help you probably.
Yeah, he's done minor subdivision before in the area, and I guess that previous people that he worked with and my current surveyor has said that, minor subdivision usually is pretty straightforward, so I guess it's, stuff always changes, huh?
Yeah, it's section 10. Section 10, requirements for submittal of final plats.
Madam Chair,
Chair recognizes Commissioner Reeves.
Ms. Garcia, I realize this can be found online, but I think sometimes, just like I love a good tangible book, I think that maybe could you hand him the sections that Commissioner Rush is referencing, so that he has it? Yes. I think that would be helpful. And then when he goes to reference it online with his uncle, maybe, or whatever, it might be easier. We're not trying to make this cumbersome for you as the agent for your uncle. Mr. Rush is just trying to make sure all the i's are dotted and t's are crossed.
Yep, I
Okay.
understand.
And Madam Chair, I just have one other point. Again, in section 10, .b as in Baker, .4, .c, .11, there's an actual language that specifies needs to be added to the plat, and I didn't see it on there. I won't read the whole paragraph, but there's a paragraph that's supposed to be added to the plats that I saw missing. And that was section 10, .b as in Baker, .4, .c, .11. And Madam Chair, with that, that was all I had. And I apologize to Mr. Bradley for dragging you through all this.
That's your job.
And Madam Chair, Mr. and Commissioner, I'm going to take a look and see if that is still a requirement. It's in this ordinance, but a lot of what's in this ordinance is old. So let's take a look at it. I'll take a look at it.
That's fair. I appreciate that. Thank you, ma'am.
So I know we talked about the copies of PUE, the airport safety overlay. What were the other,
So-
the EPCOR,
Clarification with EPCOR.
EPCOR clarification?
So I believe we've taken care of the ownership. I think we addressed that issue, right? We've
Mhm.
closed that out. So there's the condition of, so if we were going to approve this, these are the conditions. So we've got the condition that we determine if there are rights that need to be purchased or clarify the will-serve letter. The final plat needs to show the aircraft imagery surface. We need copies of the easement to make sure that it has been dedicated to the airport sponsor and that the easement is actually acceptable to the airport sponsor in that.
Madam Chair, Commissioner, if they were the recipient of the easement, it's probably acceptable. So I'm thinking what you.
Sure. I was just going by what was the wording and how I had documented it when I had tried to list everything to help us out here.
Okay, so you're stating that that really is already there?
Well, there's a copy, we need a copy of the easement.
Okay, we need a copy of that, okay.
And I'll follow up here in a minute after he's done.
Okay.
I want to make sure I got the same list.
Okay.
And then I think in the end is just all the missing plat details that I went through. And I can provide that list in writing instead of going through it again. And so I was just going to say the missing plat details
Well, I think
of section
we could,
10,
yeah,
B,
the missing plat details of section 10,
3 and 4.
yeah.
Mr. Rush, you said that you could provide that in writing. Could I get a copy of those
And
missing plat details?
I don't mind doing that, but I just want to make sure that we do this in the proper process. And so I can't answer that. I'm afraid to answer that myself. I don't know.
All right,
Email it to me.
or I can go through it now. I think I got most of them here. All right, I think what we have is a copy of the airport easement to confirm, so if approved, it would be conditioned on provision or supplying the airport easement and confirming that in fact the recipient of that easement is satisfied with that easement. Number 2, a clarification from EPCOR on whether or not water rights are required or not. Number 3, copies of both the PUEs, the public utility easements. Number 4, applicant's address needs to be inserted somewhere. Number 5, the private road needs to be marked private. Number 6 would be and I'm going to check on this, whether or not the language that's required by C11 needs to be on here, or whether that's been superseded by some of his other standard statements. Number 7, conditions on adjacent land significantly affecting the design of the subdivision, including the approximate direction and gradient of ground slope. So I would note that that says significantly affecting the design of the subdivision. So if there were a massive arroyo going through there, that would have to be shown. Otherwise, I don't think the gradient on the property is relevant, right? So I guess, Mr. Bradley, what I'm saying is confirm with your surveyor that in fact there aren't any sort of significant
gradage or slope
Correct, yeah.
that would impact
Yeah.
development?
And looking at, you know,
It looks pretty flat.
it looks like rabbit
So,
country.
so in the lack of information, should there be a statement on the plat that says there's no significant gradients or drainage or storm drainage issues?
That's not usual,
But,
no,
yeah, but how do you know it just wasn't left off?
yeah.
You know,
We could get a certificate, we can get a follow-up letter from a surveyor saying there are none.
right.
So
But in the future, what would be the best practice to follow?
maybe changing this language to say, or a representation from the surveyor that there are none,
Okay.
right?
Or and that could be a statement on the plat too,
On the-
right?
on-
Yeah.
Or on the application, you know, it could be a requirement of the application.
Right, yes.
And I am working with Rebecca on checklists, and we are redeveloping our checklists.
Ms. Winter, did you finish your list of things?
Maybe, maybe not.
I think we have a few to address.
Okay, I think those are the ones I have.
So the address of the applicant?
I got that.
Address of the owner,
Yes,
okay.
I got that one.
County treasurer certificate statement,
Yes, I did miss that one.
zoning on adjacent and on, the actual property, including the, and I don't know if you missed it, the airport imagery surface.
Where do you, oh, I see.
Because of the airport's overlay. I think that's it. I'm a little afraid we might have missed something in there, but that's a good cut.
It's section 3, it's 3.25.
Are you looking,
Yeah. Yeah, the airport one. 3.25. There was just a second.
it's 25.3.d.1.
Is it E.1
Well, that's the,
overlay?
yes,
Yeah.
that deals with the airport imagery surfaces.
One way off. There we go.
And what are you looking at now, the zone code?
This is under zoning.
And this is
It says
page,
zoning and it's
page-
overlay zones.
page 60?
Page 54.
I think it becomes
Where it
60.
begins, yeah.
Yeah, about 59
And
or
then
60.
actually, it's, yeah, I
Airport
think
is
it is on
59.
60. 59 at the bottom, airport safety. And it continues over onto 60 under procedures.
So I'm going to say that,
D.
that probably does not apply here, because this applicant already has a zone, right? It's already been zoned.
Okay.
Good point.
I
Good
agree it's
point.
been zoned, but
Right.
this is
Okay.
something that's needed on the plat.
When you come in for an application, for a zone change or a zoning designation in an airport safety overlay zone, you need D123. But there is no zone change pending here. This is a subdivision.
That's correct, but I think by the comprehensive plan and requirement that I look out for the safety of the community, that I think this is the safety of the communities, so that nobody builds, and it's also preservation of the airport, so that nobody builds something within that airspace that the plane's gonna hit as it comes coming in to land or take off.
Right. But I think for purposes of the applicant, he has to know exactly what you're talking about.
Yes.
What is it you're asking for here?
Well, no, okay, and so I went through that, and I'll go through that again, and I can look at it. So there is, the town has already determined that there is they call it a runway overlay zone, and that's on the zoning map.
Right.
But in the zoning ordinance, they refer to it as an airport safety overlay zone.
Correct.
Okay, and so it's required that that be dealt with, and there needs to be a map that is drawn, a drawing that shows how that exists relative to this property whenever there is a use change. But what I could tell by research, a subdivision is considered a use change. And so this is a use change, and so therefore, and also I would say because of the comprehensive plan and just for pure safety basis, that you need a airport imagery surface. And that is defined by a primary and a safety surfaces definition that's actually in the zoning specification. And let me pull that up. And those are defined in the definitions. And so if we go through, let me get to the definitions.
Madam Chair,
Chair recognizes Commissioner Reeves.
I greatly apologize for asking this, but can the discussion continue and I run to the restroom really quick? Is that okay?
Entertain a motion to take a recess
Just like
for
2 minutes.
5
So-
minutes.
So moved.
2.
Okay, second?
I second that.
Okay, we'll do a 5-minute recess, returning, 5 minutes.
I apologize. I am
right, calling the Town of Edgewood Planning and Zoning Commission meeting for October 16th, back in session.
So, Madam Chair,
Chair recognizes Commissioner Rush.
so I was attempting to answer Ms. Winter, her question about what I was asking for, and I think that what I'm asking for is that there needs to be a drawing of the approach surface on the plat. And so it's my understanding that a subdivision is a land use issue, and so, and this is a safety issue. So an approach surface is defined on page 4 of the zoning ordinance. And it begins with the primary surface. And the primary surface, is my understanding, is a 200-foot width beginning at the end of the runway on both ends of the runway. And it extends out uniformly to a total of 450 feet wide, okay? And so if you think about a parallelogram that starts off, let's just say on a flat surface, it starts off, it's 200 foot wide, and it's going to extend out for some period of time, which I'll later define or for a period of length that I'll define in a second, out to a maximum of 450 feet wide, okay? And so it extends out based on the definition of approach surface. And on page 4, underneath approach surface, it extends out for a horizontal distance of 2,500 feet, which is almost to the very end of the property we're discussing, from the end of the runway. So if we picture a parallelogram starting off as 200 feet wide, and it extends out, on the other end of it, it goes out, it's 450 feet wide, and but in that, the length of that is 2,500 feet. But it isn't really a flat surface, it's a sloped surface. And it slopes at a rise of 1 foot. Well, it's if you think about rise and run, but it's really run and rise. So it runs out 20 feet and then goes up 1 foot. So for every 20 foot you go out along that 2,500 foot of slope, it goes 20 feet out and up 1 foot. And so that defines the plane that needs to be drawn on the plat, since there is a overlay zone. And so that way you don't build a building or a telephone pole there that a plane's going to crash into.
Okay, Madam Chair, Commissioner, so are you saying that the airport easement that's already there,
Those are two different things. There's
Okay.
there's an easement,
okay,
and then there's a approach surface
okay,
that's defined in the zoning ordinance.
okay, I see the definition of it, but where is that definition used? Can you tell me that?
I don't understand your question.
Well, there's a definition of it, but it's not referenced. Those three terms that you're speaking of that are defined are not referenced in the airport safety.
Yes, okay.
Okay,
It's referenced.
Tell me
It's
where.
referenced. Let me look at it here. I tell you. It's section 25.3.d as in David .1, and that's like page 60, I think. It
25,
25.3.d as in David .1. A
a
map.
map or drawing showing the location of the property in relation to the airport imagery surfaces. Okay. So that is required when an applicant is seeking a land use or limited land use approval in an area within this airport safety overlay zone. So this is zoned R1. That is a use. R1 is a use.
So,
R2 is a use.
so is the subdivision.
No, a subdivision is a subdivision.
The subdivision is a land use issue.
It's,
And I understand what you're saying is that, no, this isn't a zone applicant, but I could also argue that it's a safety issue that as a representative of the town that is supposed to be responsible for looking after safety of the community by the comprehensive plan, and therefore can require this so that, because I don't want the airport to go away. It's a part of the community, it's a Plaza community, everybody wants the airport. And so if we start building things that blocks planes, that planes crash into, then the airport goes away and the community loses out. So what I'm trying to do is actually trying to preserve the airport as the comprehensive plan states, and by definition, what I've been able to find and research on the internet, that a subdivision is land use, but it's still a moot point because of the safety that's required, and the safety, this is the best way that I know of to make sure that we continue to support the airport by including the simple little drawing that we already see on the zone map.
Madam Chair, Commissioner, when this was designated R1, what you're pointing out to should have happened at that time. When somebody asked for this to be designated R1, at the time they came in and said, this spot here shall be designated R1, they would have had to have come in and complied with the procedures then and there, D1, 2, and 3. So at the time this was designated R1, that is the time that this would have happened. So theoretically, what you're saying should have already happened.
And it may have. Maybe it should have been put on the plat and didn't. But just because it was done wrong doesn't mean that we continue to ignore it. It's a safety issue. We don't ignore safety issues because something wasn't done in the past. We're going to already have to update the plat. So as they're updating the plat, just add the little parallelogram. And I understand, Ms. Winter, what you're saying. I understand that point, but I think there's other points that,
Yeah.
and so at this point, in order to proceed to resolve this, and since we're really in a discussion with the commissioners, and so my point would be that I would not vote to approve this plat without that. And you each get your vote of how you would like to proceed. I think that's the only way I know else how to solve this.
And then let me also point out, Commissioner and Chair and Commissioner, this doesn't require it be on the plat. It requires a map or a drawing.
You're absolutely right.
Right,
And-
and so I think a surveyor, I'm thinking about what a surveyor does. And he's gonna look at that man cross-eyed and say, what are you talking about, right? Because there might be a map or a drawing, because this has already been designated R1. And when someone came in and asked for it to be designated R1, maybe this was required at the time, don't know. But it also doesn't say plat. Plat is something that gets filed with the county clerk, county record. These guys are pros, they know exactly what they're doing. So I think my recommendation would be, if you're gonna require it, I wouldn't require it on the map. On the plat, I would require a separate map or drawing and see if it can come up,
And I understand, that's the wording, but for it to actually do any good, and I will go back to, it's our requirement to look out for the safety of the community. It's our requirement to look out for the vitality of the community. The vitality is having the airport as a benefit. The comprehensive plan wants to have the airport stay, and so therefore, in order to have the airport stay so that you don't have structures blocking the landing and taking off of planes, that we should include it so that nobody builds a structure that would prohibit aircraft from landing at the airport.
And then, Madam Chair, Commissioner, let me make one other point. This is just a subdivision approval. They're gonna come in at some point and ask for development approval, correct? So at the time of the development approval, you are absolutely gonna have to have them comply with all the provisions of the airport safety overlay zone, okay? There's it's replete with other suggestions or other requirements that all the owners of the properties, before they come in for a building permit, whether it's residential, commercial, or industrial, they have to demonstrate that are lesser than 50% or 1,000 square feet shall, as a condition of obtaining such permit, check in with the airport sponsor. So once they build on, once they come in for a building application, they're gonna have to comply with this. So I understand your safety concerns, and those safety concerns are articulated in the zone code and require certain things to happen before you can get a building permit. All I'm suggesting is that for purposes of a subdivision, I don't think you need to have that overlay. Other than the easement, you don't have to have the surveyor put anything on the plat.
So the fact that they have to put zones on the plat, isn't it the same correlation?
I mean, it's all gonna be R1 all the way around.
But still required to be put on there.
I think we have that on the list.
Right, and so within that, I'm saying, well, okay, as a minimum, just add the overlay zone, needs to be on there. We put the water restriction zones on plats, so why don't we put the airport overlay on the maps, would be my argument.
Yeah, and I'm just telling you that there's no strict requirement of that in your code currently.
Correct.
Right.
And so I haven't heard any debate or argument from my commissioners. My previous statement still holds.
So I think one thing that under the section 6, which is subdivision, section 11, page 20, it's waivers, variances, and modifications. And it says, whenever the tract to be subdivided is of such unusual size or shape and/or surrounded by such development or unusual conditions that a strict application of the infrastructure requirements of this ordinance would result in real difficulties and substantial hardships, the P and Z Commission may waive, vary, or modify those requirements so the applicant is allowed to develop the property in a reasonable manner, but at the same time so the public welfare and interests are preserved. So this is an airport area, is an unusual area. It's not your normal area. So I think also taking this into consideration, I like Ms. Winter's suggestion of a drawing of some sort, so that maybe that would be a condition of approval, so that we're not creating a substantial hardship.
Well, and then it comes into the record, it's part of the application, it's on file whenever somebody comes in to seek a building permit, we see it. Okay, and it might already exist, I don't know.
It might already exist.
I don't know what their records are
Yeah.
from when it was.
So, but I
sold
also
R1.
want to prevent a substantial hardship in some sort of development, if we can go ahead and put that as one of the conditions.
I understand that point, and it means that I value that. My logic being there's quite a few things we need to add to the plat anyway, and so having the draftsman or whoever does this add a simple parallelogram by the definition, or just draw that there's as he's having to put zones on there anyway, so just indicate that there's an airplane safety zone there. I mean, as a minimum.
I think either way, we still are talking about having a condition on there that we would be able to get some sort of document
Yeah.
showing that. And would that, that's more what you're looking,
Yeah,
sometimes getting, whether it's on the plat or whether it's another drawing indicating that, maybe that would work also, just so it's part of the record.
I just hate, I agree.
Okay, maybe that would work. And that would maybe ease any substantial hardship. It's, we're just trying to kind of balance it here. Because yes, I agree with public safety, because we do. That airport is, it's a wonderful place, and we don't want to jeopardize anything. At the same time, we want to allow some development without a lot of hardship going through that. And if we can get some sort of thing that we can put into the record that shows that area, whether it exists already, possibly it does. I'm assuming that it probably does. Yeah.
Madam Chair,
Chair recognizes Commissioner Reeves.
are we at the point for deliberation between the commissioners? I was not certain.
Any condition, or any additional discussion? Okay.
Madam Chair,
Chair recognizes Commissioner Reeves.
I would have to say that I think Commissioner Rush's points about preserving safety and preserving the airport are very valid points. I grew up very close to that airport, and I would like to see, as was community input into our, I just lost the words. Thank you. To the comprehensive plan, everybody would like to see that preserved. But I do have to say, I really agree with your point on putting additional input, and Ms. Winter's comments, possessive, on the survey, looking at, the surveyor looking at Mr. Bradley and really being unsure. And if he then has to have a deliberation with the surveyor and more strife, I think that entering a drawing, like the town's attorney has suggested, would suffice. That is my opinion.
Madam Chair,
Chair recognizes Commissioner Benino.
I would agree with Commissioner Reeves. I think that we do want to keep from having unnecessary hardship, and I do believe that we would accomplish, quite honestly, I can't imagine someone deciding, oh, I'm going to build something here when they're that close to the runway. But I realize we have to preserve the safety of the town, and the airport. So I agree with you, Commissioner Reeves, that I feel like having a separate drawing would be adequate to have it as part of the record.
And Madam Chair, I do understand Commissioner Rush's point about it just be so easy and cut and dry. I've learned that about you, and I totally get that. But it does give me pause that the town's council has said that the surveyors might look totally dazed and confused about having to do that. So I just don't want to create strife when maybe just a drawing would suffice.
Madam Chair,
Chair recognizes Commissioner Rush.
I could support this approach. I would also like to say, I don't care if the surveyor looks cross-eyed. He's paid to do that.
Yeah, understood.
Madam Chair, so I want to, now that I've had a few minutes to read this in some context, the language Commissioner is pulling from is the zone code, correct? Zone code also deals with applications for development, uses, residential, zone changes, those sorts of things. So this section says an applicant seeking a land use or limited land use approval in an area within this airport safety zone shall provide the following information, and any other information required in the permit application, okay? So it's speaking to permits, okay? Number one, a map or a drawing showing the location of the property in relation to the airport imagery surfaces. I completely understand what an airport imagery surface is. The Planning and Zoning Commission or its designee shall provide the applicant with the appropriate base maps upon which to locate the property. Okay, number two. Number two, the second requirement is elevation profiles and a site plan drawn to scale, including location and height of all existing proposed structures, measured in feet above mean sea level. And number three, if a height variance is requested, letters of support from the airport. Okay? So what this is speaking to is when you come in for either a zone change or a development permit, you are going to build something. This does not necessarily apply to a subdivision. So in the fact that it's requiring an elevation profile or a site plan, he's not even close to that, right? He's nowhere near that. So again, what I'm suggesting is I understand the safety consideration, but my suggestion would be that as another condition, rather than even bringing in a map or a drawing showing it, I mean, you could do that, but another condition would be that upon application for any permit, which is when development happens, that they are absolutely required to comply with the overlay zone requirements. And that's what this language is for. So it's not really applicable to the application that's pending before you. But you kind of have to read it in context. It's really about what's happening when he comes in a year from now and has 3 or 4 mansions scoped out on that thing, right? So that's what it's about, okay? And at that time, that is when he's got those homes spec'd out and drawn, that he will also have to show the airport imagery surfaces. He will have to show the elevation and profile. And if he's got a 3-story residential house with a turret on it, he might want to come in and ask for a variance, okay? So it allows all that. So that's,
So Madam Chair,
Chair recognizes Commissioner Rush.
so I think if I understand what you're saying, Ms. Winter, is that the permit process will catch this and that it's a moot point, and so at which point I would apologize for even having us go down this rabbit hole.
yeah, no, that's okay, because, we're learning something, right? I mean, it's educational. Sorry it's on your time, but, it's, that this information is required when you seek a permit, okay?
Thank you that's good clarification.
And is-
It was good discussion also because we're very concerned about,
Right, well, it's safety and
Yeah.
it's prosperity of the community.
Yeah.
So is this the type of language that should be in the ordinance? Is this normal, or should this be removed in future editions?
No, Madam Chair, Commissioner, you guys put it in this ordinance at some point. Somebody in the town put it in the ordinance, right? Because they had a concern for the airport. So it's still in there. I know that I was instrumental in editing and amending the zone code 3 times in 2023, 2022, and 2024. And it stayed in there each time, right? Nobody changed it. We added a historic bit, I think we added some other overlay zones. That's why I'm sort of familiar with this a little bit. We added additional overlay zones a couple years back. And then they've updated it. So, no, I think it needs to stay in there. And I think one of your conditions of approval on this one would be absolute compliance with the airport overlay zone upon permit application, right? Because, it's still a priority to the community if it's still in there. So I wouldn't change any of that. Now, if you were asking me, should we put something in the subdivision ordinance that requires this too? I think that would be belt and suspenders. You're catching it.
Agree. It would be my recommendation to keep the zones to be added to the plat along with any overlays. The current ordinance, subdivision ordinance, does not specify overlays, and it would be my recommendation to include that in the future.
Okay, so to double back on the plat deficiencies. Just want to make sure I got them all, because we're going to have to be crystal clear with him
right.
on this.
So, can I go through my list? Would it be helpful for me to go through my list? Because one of us is going to have to say this.
Okay. Go ahead.
So upon conditions of the EPCOR water will serve letter clarification,
Right,
copy of easements for the runway and public utility,
correct.
the missing plat details, which include
Okay,
address of the applicant,
right,
indicate that the cul-de-sac and road are private,
correct.
existing and proposed conditions of the site. Let me see, bear with me a second. I think zoning on and adjacent to the site, the county treasurer certificate, 10 years. I'm abbreviating. We don't need site designation, we don't need utilities, we don't need anything on, there was going to be a documentation from the surveyor for existing storm drainage. Is that how we want to phrase that?
There is no storm drainage located on that site.
Okay, so So we're gonna remove that as a requirement?
It just doesn't apply.
Based on your evaluation of the picture?
Well, storm drainage is usually a structure, or a channel, or a canal, or an easement. And, yeah,
And conditions of adjacent land, if applicable, direction of gradients and ground slope?
I think we talked about that, and I think we decided that we would like some sort of statement that,
And that's what I was
that it
referring to.
doesn't apply,
Okay, that it doesn't or does?
does not apply. Like, there is no significant, I
A-
think
A, a statement from them saying that it does not apply.
yes, that there is no, I think the word in this, in the ordinance was significant.
So I would say statement of survey.
Significant grade or slope.
Yes. So a statement from somebody, probably the applicant, that there is no significant grade or slope.
Statement from applicant. There is no significant.
Grade or slope.
Okay. Bear with me. Okay, so on these, on the plat edits, we've got name, address of applicant, private road, statement from applicant, there's no significant grade or slope, zoning on and adjacent to the site, county treasurer certificate for previous 10 years' taxes. And the last thing I had was that paragraph, and Ms. Winter, you said you were going to,
I'm gonna look and see if that's absolutely necessary.
so what should we say in the,
I'm gonna guess that that language is being pulled from a statute somewhere.
okay, so,
I'll
but what
figure-
do we do here?
We need to confirm that it applies or it doesn't apply.
Okay, so I'm going to say confirm public utility statement.
Correct.
Okay,
And then the county treasurer thing is not something that's a plat-related thing. It's just a potential condition.
Yeah, that's not plat.
Right.
Okay, just a condition.
Right.
And these others are plat.
okay, but that's something that's supposed to, okay, because it's a certificate, you're saying it doesn't have to go in the plat.
No, it does not go on the plat.
It's just, yeah.
Okay, certificate, okay.
No. It's kind of in that category of copy of the easements, copy of the PUEs, clarification of the water rights. And then I think every other potential condition is really a plat-related issue.
Okay, I think we've got it, and
Mhm.
Okay.
Mr. Bradley, I would say thank you for bearing with us. Madam Chair, I'd like to make a motion.
Okay. Chair recognizes Commissioner Rush.
Madam Chair, a motion for approval of the final plat subdivision application, John Bradley submitted to divide one lot into 4, located at 1 Taxiway Sandia, Township 10 North, Range 7 East, Section 13, Tract B3. There's 23.92 acres. It's fully located in Edgewood, Santa Fe County, New Mexico, 87015. Partial 9447539-2, under the conditions that you clarify the EPCOR will serve letter and if water rights are required to be provided. Copy of the easements for the runway and the public utilities. Missing plat details to include name, address of the applicant, document that the road is private, and that includes the cul-de-sac, A statement from the applicant, there's no significant grade or slope, if that's the true statement. Includes zoning on and adjacent to the site. A certificate from the county treasurer for the previous 10 years that the taxes have been paid. And then verify that the statement that's documented in the ordinance, section 10.b as in Baker, .4.c.11, that deals with public utility easements.
Madam Chair, I'd propose to add to that an indication of all the zoning on the map, and a requirement that they comply with the airport overlay zone as a condition to any permit.
Yes, and include, is that good enough statement?
Yes.
Okay, I thought I said on the zoning, but I forgot about the other statement, yes.
Do we have a second?
Second.
Any discussion prior to?
Madam Chair,
Chair recognizes Commissioner Reeves.
I have a question more than discussion. Thinking about this limited power of attorney, it's very specific on here that says land division of lands of Richard Dennison. Was that the original plat name? I just need some clarification. Was that the original plat name that we dealt with in January? Okay, so then after the approval of this, the plat name will change, right? So this is just legal counsel, I guess, question. The limited, should Mr. Bradley, John P., who sits before us this evening, come back as acting agent, this power of attorney would need to be updated, or am I incorrect?
No.
Okay, that's what I needed clarification on,
Madam
just
Chair.
for future.
Yes, Commissioner, it appears to be spot on in the designation. Even his draft revised plat indicates that this was originally designated as the plat of survey entitled Land Division of Lands of Richard Dennison, Tract B.
Right, okay, all right, I just needed to have clarification on that. I have no further discussion on this matter.
Okay, discussion closed. We'll call for a vote. All in favor?
Aye.
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 Any nay? Okay. Let the record reflect 5 ayes. And that was the approval of the final plat,
With the conditions as stated.
with the conditions as stated.
Correct.
Thank you. Thank you very much for going through this with us. Hopefully, it's also given you some additional information as the land is developed and whatever's done with the land that you can convey also.
Yeah, definitely with the permitting and the overlay zone, I mean, I completely agree, and so does my uncle, that, this is an aviation-oriented area, and that's what we're focused on, so, and of course, safety obviously is paramount. I just have a couple questions, if that's all right. So, the conditions of what was stated before, the plat was approved, so, but with the conditions, so I'm guessing that I need to come back with the plat, with the addresses, the address of the owner, and all the other stipulations or the conditions.
And that would be
We'll have
to
have another,
Planning and Zoning
town council
Department.
meeting.
There's no need to come before us on this issue or this request regarding the land. You would provide that to the Planning and Zoning Department now.
Okay, so,
Here, yeah,
And I'll sit with you and go through it. and make
Yeah.
sure you-
thank you very much.
yes. Thank you, Mr. Bradley.
Thank you.
You have a
you, guys.
great
Thank
rest of your
you.
evening. Item number 8, matters from staff.
Rebecca, that's you.
Well, Madam Chair,
Chair recognizes Commissioner Rush.
Ms. Winter, I'm assuming that you're aware that we're making an attempt to update the subdivision ordinance.
Yes, I heard you speak of that. I heard you speak of it in
And,
passing.
and so we understand the process is that we're not responsible for the ordinance, but since we're the users, I think we're responsible for providing input. I think the planning and zoning manager, the process should be the planning and zoning manager would provide input to the town commission, who would then decide, make their changes, have you review it,
Right.
probably have us review it. And so I think our plan is that we're trying to make an attempt to provide our recommendations to the town council
Okay.
via the planning and zoning manager.
Okay. So, yeah, I mean, you can do that any way you like. You can have staff propose revisions. You could have another open meeting where you propose revisions. Maybe you've already had that meeting where you've proposed revisions. And then somebody would do a red line, to this, adding and striking, okay? Then
Would that be you doing the red line, or would that be the governing body, us having a meeting together?
I think there's no doubt in my mind, the governing body is gonna look to you to make proposed changes. There's also no doubt in my mind they're gonna have some of their own, for whatever reason. So you would probably give them a red line. So you would have your own public meeting, or maybe 2 public meetings about that, to collect information from your folks and enforcement and Rebecca and, whatever you're hearing. So you would come up then with a red line after you've had your public comment, after you've had your input, Rebecca's had her input, and you would submit that red line to the governing body for their consideration. They're the ones who will pass it or not. They have the right to add to it or subtract from it, just like you are proposing. So it could be a month, it could be a 3 or 4 month process.
Yes, given that we have manpower constraints, we had thought about 2 months, a month back.
Mhm.
And so I think we're going to discuss a little bit here, and then we'd recommend a few months out. We've also, we need to go through the process of saying, hey, town commission, we're going to actually look at this and provide you input. And so
Okay.
we haven't done that, so we'll think we're going to take that action.
Okay. Yeah, I think I would certainly inform the manager and have the manager inform the commission or the governing body that you're going to be doing this, that you'll be conducting public hearings, and that you'll be providing a red line at some point in time.
And some of us had discussed it. We thought we might have a workshop on subdivisions, and we thought maybe we would do that next month. And I'm assuming we thought we would have you teach that? So
Oh,
that's a statement and a question at the same time?
oh,
Or
like
do you have a recommendation
like a training?
on subdivisions, so that as we make changes, that would be fresh and applicable at the right time?
Okay,
Yeah, so I think your input would be critical
okay.
as we are looking through our
Mhm.
proposed
Yeah, and
items.
I would look at it from a legal eye, right? Like, is some of this language still required by statute? Because I know this is an old document, even though it's got a 2019 or a 2024 date on it. I know it's way older than that. So I can look at it from that perspective.
So
And you-
then I have another question. Because you're legal counsel for this commission and not, or my understanding is not legal counsel for the governing body, correct?
Correct.
Okay.
Mhm.
So when they would go over that, would you be present
Mm-hmm. Sure.
to answer questions for
Yeah.
them? Because
Absolutely.
it takes a long time to understand all of this, and
Right.
they don't hear it like we do at every single meeting.
Right.
So So that's kind of where I was thinking.
No,
Is
there's
that-
no doubt. I've appeared in front of the governing body in this capacity before for appeals.
Okay,
Remember
Yeah.
appeals? Yeah,
okay,
that one.
okay.
Actually, we don't get to participate in those.
Not anymore, right. And then, I did represent the governing body for some period of time as well. And they have, I don't know, they have 5 or 6 different law firms. And I know they still welcome my input, and on something like this, I'm sure they would welcome it, so.
Okay, all right. So then would it be possible to do a training next month with you, say at 5?
It'd be
For
this same, Wednesday, Thursday regular meeting.
Yes, ma'am.
Uh,
Like right before regular meeting?
Yeah, I think so.
Is that enough time for you? I mean,
November 20th, I'll have to look real quick.
well, good. I mean,
Um,
and I was before she said that, I was gonna say December would, or, I don't know if my colleagues agree or not, but I would think that December would be okay for this as well.
I'm wondering if we should
Cause I know
plan for December so that we can,
Ms. Garcia's plate
continue.
is full.
yeah, and then have Ms. Winters in December.
7
That way we're
items.
more prepared.
So that's November 20th?
Well, for me, it makes more sense to do the training in
And this is-
December
That's the 3rd?
so that we have her input
That's the 3rd.
as we work on it.
Okay.
But that's just kind of my logic.
Yeah, I'm just
I'm neither here nor there on it.
Okay.
But
Like,
I could live,
either-
I could work either way. though.
Yeah, so somebody else call it.
I'm wondering,
It
like,
looks good.
a training on,
On how to conduct the revisions or a training?
yeah, that's, I
on-
guess, that would be my question is, are we doing a training on,
On the
do we
process
want her
for
to
it?
train us on how we proceed with making the suggested changes? Or do we want her to, yeah, I'm trying to figure, so we can clarify.
Okay,
Winters.
and for me
Winter.
personally, I'm not looking for input on procedure. I'm looking for content.
Okay.
You know, what are things to look for? What are do's and don'ts?
Subdivisions, okay.
When revising.
So
Well,
we're,
no, not when revising for content. Do's and don'ts of content.
so some of
Okay.
us are already looking at the ordinance and then looking at some confusing things in the ordinance.
Perfect,
Give you an example, expedited.
okay.
So expedited within the ordinance is not particularly clear.
Okay,
We'd probably add its own subsection.
right.
You know, what are new state statutes that we should consider?
Right.
Right.
So I think, yeah, I can look at some of the language. I mean, so I'm kind of thinking about my scope here. My scope would be to review all the language to make sure that it's reflecting the most current state statute. When
Yes.
there's requirements for languages to be put on a plat, is that still something that there's a whole section on surveying in the New Mexico statutes. Is that something that's gonna work? Okay, I can look at all that. That's
Okay.
easy. And then you as a community have to decide, is this list too comprehensive? Is it comprehensive enough? And then you have to sort of think about, some of the struggles you went through in some of your appeals. Do you want more clarity around what is in fact a minor subdivision? Do you want more clarity around what can be an expedited process? Do you want to change, there is one thing I noticed, sometimes there's variances in the field, and staff has made variances in the field. I can't remember right now if that was in the context of a zone or a subdivision, but
I think it was a zone.
it might have been a zone, so, but do you want some clarity around your variance procedures? So, like Los Ranchos just recently clarified the standard for getting a variance, right? Because there was a lot of wishy-washy language in their old variance, and they wanted it to be a little more crisp. So those are the kinds of things you're gonna be looking at. I can look at the legal stuff, And then, at our next meeting, I can kind of brainstorm this and kind of give you ideas of what you should look at, how you advertise it. And we can even start the process if you like, just start talking it through as like work session type thing, and just entering those red lines or proposed red lines or thoughts. Then Rebecca can submit you a draft 2 weeks before the next meeting, which gives you more food for thought. So I would say it's probably at least a 2 or 3 meeting process. You want to advertise it because you want the folks to know what you're up to.
So I guess it comes to, I know you didn't hear him, but Mr. Rush said even starting in December would be okay with him.
Yeah.
So I guess it comes down to when do you want to start? What month are we going to dig in?
Yeah. And do you really want to dig in December?
I know, that is why I'm saying that we're coming up on,
Holidays.
yeah, holidays and apparently a very full agenda in November. So,
I think we need to consider also the constraints on our planning and zoning manager.
Right.
and we might also consider the fact that we could have new commissioners in the governing body come January.
And if you have new commissioners and a new governing body, you may have a new manager. So,
Yeah.
Lots to consider.
right. So I think that probably the most likely, I think, Chair, you might want to approach the manager and let that person know that you're considering this. And, talk it through with her on, is it still Lina?
Yeah.
Okay.
Yeah.
And talk it through in terms of when do you dig in?
Okay.
you
What
know.
would be the good timing?
Yeah, but in the meantime, I
it's-
hope you all are working on your thoughts and lists of changes. And with Rebecca's permission, I'll start looking at the old language in there and making sure that it complies with state statute. Notice, we can update notice, if you want to update notice. Notice came up today.
Yes.
Yep.
We can, I can make a notation that it says 15 days here, but state statute says 5, and then you can change that. And then one thing, staff has to recognize is that when you send it to the newspaper, sometimes it takes them a week to publish.
Right.
So sometimes it only takes them 2 days.
Right.
Yeah.
Yeah.
Okay.
So then in that instance, just for learning purposes, in that instance, the municipality is held responsible for what the newspaper didn't do, right? Or had lagging days in publishing?
I don't know if it's responsible is the right word, but.
But if they paid for it in time to, like, if they
Oh.
show I don't know, I'm just asking the
Yeah.
question.
When you publish, you have to recognize that they all have different limitations, all these publications,
Right,
like the Albuquerque Journal will get it in the next day.
okay.
But like the Sun News in Las Cruces, it'll take them 3. Aztec takes 5. Here, apparently it takes 6.
Okay,
So, once you learn that, she's got to put together agenda 3 weeks ahead of schedule. And her notice 3 weeks ahead of schedule, just to publish.
Yeah, so,
Thank
so,
God notice is just notice.
so state statute doesn't even require you to publish it. And so maybe we need to take that into consideration, maybe some kind of sliding scale that it's okay between 10 and 15 days for being published.
Well, it does say publish,
No,
and then it defines publish someplace else in a different statute.
state statute actually says you have to publish it?
This is what constitutes that.
Because the only thing I could find was that you had to just contact the name on the plat 5 days prior.
Yeah, so there's a separate statute in a different section that defines notice.
That's what scares me to death, is that I'm
Yeah.
not going to find all the details. Yeah.
Well, and that's, yes. And honestly, you just have to live through that mistake to find it. And the good news is I lived through that mistake like 25 years ago.
And then we're also looking at it from the viewpoint that it's going to be a lot better than it is presently. So even if it's not, we're not going to catch everything perfectly. but
No, and you
we're just
always have the opportunity to
improving.
amend, I mean, like the zone code, we amended it 3 times in 3 years. And there's still typos in it, and that's, that's on me too, but, I was told what to do, right? Like, I was told you need to add this new overlay in here, so. But there's a lot of stuff in the zone code that could use a little bit of attention.
So one thing that I was struggling with was format of the document, and we talked about, Manager Garcia and I, about looking for a template that the clerk may have to use. Because basically I created a whole new version. And so,
You could certainly
do
reorganize.
you have what do you recommend for format?
Everybody has their own gig, right? Everyone has their own thing. Let me look at your table of contents.
And I think in the format, we may be looking to simplify even the ability to read the components of the documents, because paragraph reading is not the greatest.
So the first thing I would do is, I'd probably make it a bigger font. That'd be the first thing I would do. I would make sure that every single definition in here is used someplace else. I do notice that there's a lot of weirdness, like section 6 has a subsection A and B, but then starts with 1, 2, 3, 4, 5. So your numbering has to be revised. That's true in both ordinances, and that will be paralegal or clerk work, not
Well,
lawyer
and
work.
that's where I was looking for what, format to use for all the sub-paragraphs, and then like to get into the 21st century and have the table of
Yes.
contents generated automatically.
Yes, I mean, right now, the way I get through it is I OCR it, I read it digitally and save it, and then I can scan it for any word I want. So I'll just open it, and I've sent Rebecca a searchable version too. And it changes your life, but
Yeah.
it's not, I mean, the way it's, I mean, there's a big A and then a 1 and then a little a, and then it goes back to a big A, and it's kind of messed up. But it's, it's just years of tinkering. Yeah, years of cut and paste, right.
I would say I've already put 2 days into trying to get that right with Word, and it's a nightmare.
No, that's what legal assistants are for.
I don't have one of those.
Oh, okay.
This mom could use one.
Yes, we could all use a legal assistant.
So, Commissioners, I'll go ahead and speak with Town Manager and get her feedback on timeframe. And then, next meeting, I'll let everybody know about that, but in the interim, we'll continue to look at do we want to focus on subdivision first? I think that's the last, this discussion we had before is subdivision first, is
My
what we want to
my
focus on.
recommendation was, since it seemed to be the oldest,
Yeah.
did
Okay.
we?
So we'll
did
stick
we-
with that again.
Did we decide whether we want to do a workshop in November and December or not? Or are we going to wait and see?
I can just update you on what I can look at it and kind of update you on what I think my scope of work would be,
Okay.
all right?
And then we can take it from there and, yeah, well, we'll discuss it the next meeting then, November. Then we'll have Nina's feedback. Okay.
So
And then
we'll-
we'll have some of Ms. Winter feedback.
So it'll just be an agenda item?
Agenda, we'll just make it an agenda
In
item.
the staff matters section,
Yeah,
okay.
for next month. Continue discussion about subdivision ordinance again.
Do you have an extra one of these?
And then
I
maybe
wanted
at that
to
point, we
share
can
one of these
decide on
pages.
a workshop.
I'm good with that.
I think
What do you
that's
think?
great, yeah.
Okay.
I was gonna give it to him.
Because the holidays do get hectic.
No, just
Yeah.
the page.
As far as having,
Oh, he doesn't?
well, or having community input, it doesn't happen then.
That's true, that's true.
Right. So he should have it with him right now. Okay. All right, sorry, I wrote it on your thing.
Okay. The other item for under matters from staff is zone amendments in November.
How many do you have 7 of those zone changes?
Oh, yes, we are we got 2 package of, so Rebecca and I have been combing through zone amendments that weren't processed properly. Okay. And then we found another 7 potentially that, and remind me, they're older, and we're not sure if they were published, but my legal assistant is looking for the publications now.
Oh, okay.
So I'm not sure they'll come to you ever again. They're really a cleanup for the governing body,
Okay.
but
And
they,
then there's a review ordinance for zone, for the zone map as well. So every time that the zone map is updated, that needs to be in ordinance as well.
right, so here's how it works. When you guys approve zone changes,
W-
right?
We recommend.
Yes, you recommend. Correct. You recommend.
Good call.
So then it goes to governing body for a change. But the law says that an ordinance, a zone change is an ordinance change. So when you key on the word ordinance, that means you have to notice it, publish it, approve it, and then publish again. So you all recommended 7 zone changes that were adopted by the commission, but were never published, never approved by ordinance, and never published again.
Okay.
So all they did was approve findings of fact and conclusions of law
And that's where it ended.
without an ordinance. And then when we went back and looked at all the old ones, they were all approved by ordinance. And somewhere in the 21, 22 timeframe, somebody forgot that you had to approve zone changes by ordinance.
Okay.
Where's that process defined? Is that a state statute?
State statute.
See, that's the reason why I wanted the overlay zone on the plat, because things don't get followed through the way they're supposed to.
Yeah. Yeah, I hear what you're saying, but theoretically, that should be picked up in the permitting process, right? But I just know what, I know what surveys do, right? Somebody would lose their mind, I'm sure, but, yeah. But, I mean, you know, what would be nice is if you know a local surveyor, ask him. If you know one, ask him. What would you think if we did this? You know? There's gotta be somebody local.
Anybody know one?
He found
Anybody
somebody.
have one in their back pocket?
No.
I don't
no,
either.
No, not a local one. Okay.
Anything else?
All right. And then item number 9, calendar update and future agenda items. We just have the next regular planning and zoning meeting on Thursday, November 20th.
What other motions?
What date? Let me look at that.
The ones outside, okay, those are going.
It's on Thursday.
Thanks.
And then the December one is December 18th, I believe. Okay. Motion to adjourn?
Madam Chair, I motion we adjourn this meeting.
Second.
And we are adjourned.